All right. There is a clear difference between asking 3 times for ID and declining, saying, I refuse to identify myself. There is a big gap in between these two actions. One is practiced in Louisiana, in Natchitoches, where I got arrested, where they practice the cops asking 3 times for ID, then jumping into an arrest. And other states I've been in where the cops will ask me if I'm refusing to identify. And if at that point, if I say no, or if I say I am refusing, then they could take me under arrest. And this is a standard within the police training and how courts will prosecute with making it clear. Anybody with a clear head, or they demonstrate that they have a clear head about their decision in the courts, then the courts can be satisfied with going forward with a conviction or with their decision. You have to at all stages make a clear-headed decision on going forward with your choices. And in Louisiana, they don't even allow that. And I got convicted based on asking 3 times, and me just hanging in the balance. I mean, once I'm arrested, that's their decision. They just assume I wasn't going to identify myself, and then the courts assume that I'm not going to identify myself either, and that standard is so incredibly low, and I'm surprised that nobody has debated that, because in other aspects of law enforcement, there's DUIs where people have to make it clear that they're not going to submit to the tests, the physical tests, or even the breath test. The cops ask, do you agree to giving us a breath sample? Do you agree to giving us a blood sample? And then the subject, they can agree to it or decline. And if they decline, that's like you see on these videos on YouTube, they got an instant arrest at any point if the person who's pulled over for DUI refuses. And then the cops just use that evidence there. And the cops make sure it's a clear declining of the request. And that's for DUI. I mean, there's other ways that the cops ask for permission, like they'll ask to enter your house, or search your car. May I have permission to search your purse, your person, and you can say yes or no. But I mean, they make it clear if it's a yes or no. I mean, you could ask questions and go back and forth, maybe ask them, what are your limits for your search, and what is your probable cause to search me if I decline. but there needs to be clear in the record a yes or no, and I've been dealing with a crime of failure to ID now. This is an active case still for almost 2 years. 2 years in January in Louisiana, sitting on the Supreme Court's desk, collecting dust, and it's an arrest based upon asking 3 times compared to yes or no. Making it clear on record, yes or no. And my lawyer really didn't argue the yes or no, and I didn't bring it up in trial. That's what I've been told, that because I didn't bring up the clear-cut actions, the clear-cut declining to ID, or the clear willingness to ID, that wasn't argued, because I didn't know really how to compare. I mean, the closest I could compare it to are DUIs. The cops have to make it clear so that they can get that conviction. They have to make it clear. Are you willing to submit to some field sobriety tests? Yes or no. And if yes, then they go through with it, and then use that as a guide for your criminal trial for DUI. And if that's a standard, I mean, it cannot be exclusive to DUIs. I mean, ID needs to have a standard to lower this, and to lower the standard of a DUI to asking 3 times and then jumping on the victim that these pigs arrest is really sick. I mean, in my opinion, I'd have to do a proper survey to see how other people feel about that. But the judge supports it. Judge Owsley supports it, and he's supposed to have be the guy that everybody voted for, who's tapped into the pulse of the public. The public voted for him into city court. I mean, but I mean, on every issue, I mean, you can't expect them to get it all right. So I just want to make it clear of the differences and how what I'm facing is the lowest bar I've ever seen, for the lowest standard I've ever seen, and then just not putting enough effort into arguing that as a matter of law. All right, before this even goes to trial, this is an argument to make as a matter of law that I failed to bring up, because I just couldn't quite wrap my head around it. I had to watch a few more of these DUI busts on YouTube to see that the cops make it absolutely clear, yes or no. Are you willing to submit to these tests? And that's on YouTube. That's the entertainment part of learning the process of policing and possibly defending yourself against these charges. I haven't really seen anything else. I've seen cops ask to enter the house, and a lot of people say no, and so then the cops have to get a warrant from a judge. A judge signs off on the warrants if the cops show the judge that they think they got enough probable cause to find some kind of evidence inside. But yeah, the asking for permissions has been degraded, has been degraded, and it takes people willing to stand up against being pushed back. I mean, do you want to end up in jail over these lowball issues of being asked 3 times and then instantly being arrested? Or would you like to stand up for yourself outside of jail and raise the standard outside of jail rather than asking where did the system go wrong while you're sitting in jail? So I'm just presenting these two differing subjects here.